So last week, Uber was fined 290 million euros for transferring personal data to the US by the Dutch DPA. I have some issues with this decision, and I think it reveals what a mess the GDPR's rules on international data transfers are. So I'll be asking whether Uber really deserved to be fined such a large penalty. Google has suffered a setback in a class action about Chrome, and the reasonable user has scored a point against them. And two Swedish pharmacies were fined for using the Meta Pixel despite having consent. I'm Robert Bateman. This is the Privacy Corner. Big thank you to Privado AI. So, first of all, Uber's fine. Now, I don't think this decision, in essence, is necessarily wrong, but I think it was a little harsh on Uber, and it reveals a massive problem, which is that the international data transfer rules under the GDPR essentially do not work and do not make a lot of sense and are being interpreted differently by different EU bodies. So Uber said it didn't need to use standard contractual clauses or any other transfer mechanism because its US entity was subject directly to the GDPR under Article 3.2. Now, the Dutch DPA accepted that the US entity was covered by Article 3.2, but said Uber still needed SCCs or some equivalent transfer tool. So that's the conflict here. That's why the fine was issued. So why did Uber think that no SCCs were required? Well, one of the things that Uber pointed to was some FAQs by the European Commission, which, don't forget, drafted the SCCs and indeed proposed the GDPR itself. These FAQs include the following question: can these SCCs be used for data transfers to controllers or processors whose processing operations are directly subject to the GDPR? So this is the situation with Uber US. The answer, no. The Commission appears to say that no SCCs are required in this situation. And it does make sense because the company is already directly subject to the law. Putting contractual obligations on top duplicate its direct legal obligations in part, and in some cases almost contradict them. The SCCs are like the GDPR. They impose similar obligations, but they are still different. Either you're just putting a contract on top of something you already have to do, or you might be putting a contract in place that tells you to do something slightly different from your direct legal obligations. So that does make some kind of sense. Now, when the Dutch DPA looked at Uber's argument here, it read the Commission's FAQs and says that Uber could in no way have inferred from the Commission's statements that it did not need SCCs because its US entity fell under Article 3. Really? There's no way Uber could have inferred that it did not need SCCs in this situation by reading that FAQ document. So a reminder, the question is, can these SCCs be used when the other company is directly subject to the GDPR? The answer is no. And the AP, the Dutch DPA, thinks there's no way Uber could have inferred that it didn't need SCCs by reading this question and this answer. That is no. The answer is no. I don't know how else to interpret that. I mean, it clearly the Commission thinks this. Now, these FAQs obviously don't have binding legal effect. The DPA said Uber should have read the GDPR more carefully and relied on that instead. And that's true. I mean, this is just a blog post, effectively. But the Commission clearly thinks this. And we can see in the implementing decisions for these SCCs itself, the implementing decision gives legal effect to the standard contractual clauses. And Article 1 of that decision says they are for use for the transfer by a controller or processor subject to the GDPR to a controller or processor not subject to the GDPR. So that clearly reflects Uber's position. A recital in that implementing decision, recital 7, also says that they may be used for such transfers only to the extent that processing by the importer does not fall within the scope of the GDPR. So clearly, the Commission and the Dutch DPA are at odds here. Now, the Dutch DPA is responsible for enforcing the law. The Commission is not, but it did write the law. So there is a clear contradiction between these two positions. We know from the EDPB guidelines that they disagree, and they think it doesn't matter whether the importing entity is subject to the GDPR. This is very, very clear. So Uber obviously made the wrong call here. As it happens, Uber has now signed up to the EU-US DPF, the new privacy shield. So everything's fine, problem solved for now. We obviously don't know how long that framework will last, perhaps forever, and it really does reveal a fundamental problem with how all these different bodies are interpreting the rules. Next up, Google, another long-running case about Chrome browser. This one comes from 2020, and it concerns two modes of using Chrome. So this is a case under California law, not the CCPA, but Invasion of Privacy Act, consumer law, various torts, intrusion upon seclusion, and so on. And it's about sync and sign in Chrome modes and basic browser mode. So if you use Chrome in sync mode, it remembers your browsing history, open tabs, bookmarks, passwords, whatever you like, across devices. And that information is sent to Google and stored on Google's servers. In basic browser mode, Google doesn't sync that information and doesn't send that information back to its servers. So effectively, it's a more private way of using Chrome. Now, the problem is Google does still collect some information about people in basic browser mode, even though it says to some extent that it does not in the Chrome privacy notice. So, like with any internet user, Chrome users will have some data collected when they visit a site running, for example, Google Analytics, a third-party site. Google will collect stuff like their IP address, cookie IDs, browsing history to some extent, and requests to see the website, and also a header that identifies what type of browser they're using. This is used for ad measurement, analytics, and so on. Now, this happens even in basic mode. So the claimants here are arguing that Google misled them by saying it wouldn't collect personal information if they used basic browser mode, and then doing so when they visit third-party websites running Google's business tools. So there were two arguments here, basically. The first argument that succeeded at the district court was that Google was collecting browser agnostic information. So it doesn't matter which browser you're using, whether it's Chrome or not, Google's going to collect this information anyway. So it's not covered under the Chrome privacy notice. It's covered under Google's privacy policy terms of use, all of which have been agreed by the plaintiffs at an earlier date. But the Court of Appeal found this to be the wrong line of reasoning. The browser agnostic element doesn't really matter. What matters is what the reasonable user thinks. The reasonable user of Chrome signing up to use Chrome would have thought, according to the appeal court, that Google would not be collecting this type of personal information if they use the basic browser mode. So here we have a kind of victory for plain language, being very careful about what you say in privacy notices and not relying on technical legal arguments to kind of get out of these consumer protection cases. So it's going back to the district court to be reconsidered under what the appeal court says is the proper standard, the reasonable user's impression of how their data would be used. Finally, two pharmacies in Sweden have been fined. The fines are around $3.5 million and around $800,000 respectively for using the Meta Pixel. But unusually, both companies got consent. These cases are not about lawful basis, principles of data processing, or data transfers to the US. They are about the GDPR security provisions, Article 32. So what happened in both cases, they're both pretty similar, it's just the scale and the scope that differ, is that employees of each company put the pixel on the websites, and in one case or both perhaps activated a kind of advanced mode that collected more detailed personal data from visitors and ended up sharing data about things like whether people have bought sex toys, STD tests, non-prescription medication, that sort of thing. Only consenting users were subject to this sort of processing. So they did have a legal basis, but they got fined anyway. The Swedish DPA found that the security rules at Article 32 were the issue here. There was some security measures taken by Google once they received the personal information, but the employees were found not to have properly assessed the risk and to have used these in situations where personal data, sensitive personal data, would be transferred. So no transparency issues here, no legal basis issues, no data protection by design issues, just Article 32. So I think this suggests that consent is not a get out of jail free card. There are some circumstances in which you may be taking a risk by using Metapixel or other tracking tools whatsoever. So don't just rely on consent in some situations, I suppose is the message here. Big thank you to the sponsor of these videos, Privado, who provides a tool that's very good in those sorts of situations for finding out where you're using tracking technology, helping you get it all in line. Digital tracking governance, please do take a look at Privado AI, who kindly support these videos. That's all from me this week. It's been a bit of a break, so thank you for returning to me, and I'll see you next time.